I want to talk about two words that were touched on in that presentation. But I want to talk about those two words in the context of the shooting. Before and when Jason Levesque decided to shoot. And this isn't a case just of a shot. This is 6 shootings. And I want to talk about these two words in that context. These two words are reasonable and imminent, as about to. And to be clear, these are not just words. These are the concepts and principles of a sensible law that buttresses against inappropriate and unnecessary deadly violence. Violence driven by notions of retribution, revenge, impulse, anger, and poor judgment. We guard against that with these concepts. These principles exclude unnecessary and pointless violence, but they also at the same time ensure for you, for me, for everybody, including Jason, the right to protect yourself, but within the boundaries and scope of reasonableness, reasonable force, reasonable belief of impending deadly force.
I agree, Cat Daddy.
Reasonable degree of force to respond to imminent use of force, deadly force against you. That's the framework that needs to guide your analysis of the evidence. And that's what I'm going to talk about. Let's move on to evaluate really each chapter, each motion through this process. Not to dissect, not to impose some unreasonable analytical approach to Mr. Levesque's choices, but to assess his choices and his actions appropriately. Evaluate each one of these steps, these sequences, and you'll see that at each stage, after the initial confrontation, there is actually a cascading sequence of diminishing risk. From the moment Kyle Violet stepped away, there was diminishing risk. And I want to ask you to evaluate the steps in this case concerning issues like distance. Distance creates safety. Evaluate it. Distance can be closed and increased risk. Distance creates opportunity to assess risk. So at each one of those chapters of this case, consider that as a factor. The time. Attorney Sisti said this whole thing happened in 11 seconds. You'll have the totality of the videos. It took more time for Kyle to walk across from his driveway over to Justin. I mean, to Jason. There was 5 seconds. Nearly 5 seconds between that first shot, 2001, 2002, 2003, 1004, some 5 steps towards him before he unloaded the remaining 5 rounds into his back. Consider that distance and time when you assess reasonableness. Visual opportunity. The opportunity for Mr. Levesque to assess risk. The lines of sight here, the lighting. Remember at the beginning, there was one moment in Attorney Sisti's cross where Detective Danny were saying, look, you don't even know whether or not Jason is able to see his hands because of the lighting. And yet, we see a video from 43 where inside, from 40 feet away at least, Angela is able to say, he's got a gun. Because the lighting in this case was very good. Illuminated by a high-density residential neighborhood with exterior lighting. You can see it in the video, a truck with its headlights on. And Angela having no problem identifying immediately when the gun was taken out, when Jason produced the gun, which informs you about Jason's ability to assess whether or not Kyle was armed. And so those are some of the issues to talk about, to consider when we actually walk through this. And let's do that now. This confrontation starts when Kyle walks out of his home. And despite Attorney Sisti saying at some point challenging Danny that Jason doesn't even seem to know he's there until he's at the plow. We know this, that when Kyle was walking out of his home, Jason did see him. He had a full opportunity to view him from the full 40 feet here. You were out there at that scene. You know that distance from the far end of Kyle's driveway all the way over to that plow. And we know he saw him because he told the police, I saw him putting on his shirt. You don't have to believe him. It's corroborated by the video. So we know he saw them at that point. And what does he see? He's putting on his shirt and he's able to describe his hands. You know, this is an informative moment about whether or not there are reasonable concerns about Kyle's ability to cause violence of such a degree that would justify what happens next. And nothing in his hands. You can see him putting on his shirt. There's nothing underneath. No reasonable basis to believe that he's armed coming over. Jason admits that he can see his hands, that there are no weapons, that there's no means of imminent threat as he's walking over. And let me just address this one point that Attorney Sistis said, that no weapons is just an illusion. It's a red herring. That's nonsense in a case like this. It's true that there's this phrase in the instructions that say, look, he doesn't actually have to be in danger. But that means if somebody presented a firearm that was carved out of balsa wood and painted black, the actual threat of that is zero, but the perception of it could be reasonable. That's not this case. There still needs to be a reasonable apprehension that Kyle had the means, the ability to cause lethal deadly force. And obviously something like weapons is highly relevant to that reasonable analysis, is it not? The face-to-face encounter. It's clear that there is contact. Jason's description of it actually says the tip of his nose touched my cheek. Let me be clear about that. There's nothing that's sort of appropriate. I'm not suggesting that's a good deed. Let me just clarify this point. It's non-deadly force. There's no suggestion that he is going to kill him with his nose. I don't mean to sound glib about that. I mean literally to say that dismissing that he didn't have a weapon and say that the encounter there is what drives this analysis is misplaced. Here's the reality. That moment passed without the use of deadly force. That's not when the shooting happened. And yet, in this courtroom, that is what was recreated by the defense. We literally had a recreation of the face-to-face, the nose-to-nose encounter. And you know what we never got to in that presentation, that recreation, was when he took out a firearm, closed the distance, saw Kyle stop, turn, and shoot him in the head, lower the gun, and then advance on him and shoot him 5 times in the back. We didn't see that recreation, but that's what this case is about. It's on tape. That's an ace. Each one of those videos is an ace.
Is that what happened, though? I want to see this. We got to find this video.
You know what could have happened at that nose-to-nose assault? That's the definition of non-deadly force. And you know what Mr. Levesque would have been fully within his rights to do? Shove him. That is to use non-deadly force in response. That is another corollary of self-defense. You can defend against non-deadly force with non-deadly force.
You can also
he may have
defend
even
against
deserved
a
a punch in the nose. Reasonable force. But to bring that whole episode forward as justification to shoot him is not reasonable.
It's not reasonable to say you're going to kill somebody.
It's the most intense moment of
shoveling
this
snow.
Entire episode. And yet, that's not when he was shot. And that moment was defined by non-deadly force. His hands were out. He had no weapon. He didn't claim to have a weapon. He didn't hint he had a weapon. Even in that moment, there was no reasonable basis. If he had shot him, it would have no reasonable basis to do so, and he didn't. The moment passed. He made a threat. We accept Jason Levesque's characterization of that threat, repeatedly made to Detective Garston. Never wavered about that. Not too tired to use the term, that was verbatim. Not too confused to say those were the exact words. Not too confused to repeat the conditional threat over and over and over again when Detective Garston revisited those issues to do his looping. Tell me what he said. Every single time it was a conditional threat. I want to talk about that. Let's be clear. If words are the basis to justify killing somebody, then words are really important.
Yeah.
A conditional threat, these aren't just legal concepts, I gotcha moments from the law. These are common sense analyses of words. A conditional threat is important, it's different, because it literally buffers and defers both the act and a time period of when a threat may come to fruition. I know that sounds all legalese. Put it this way, something needs to happen, and it's going to happen in the future. And that diminishes...
Walked into his yard, Derek.
It's not, I'm going to kill you for what you just did. That's imminent. Brandish a knife. I'm going to kill you for putting the snow next to the pole. It didn't happen. Something else had to happen. And it would happen in the future. And then, still, Kyle would have to have the means to actually do something lethal and violent.
It is imminent because...
this is a pretty...
see, this is my issue with this. It is imminent because what if a snowflake falls off of the pile that Jason had on Kyle's side of the road? And Kyle turns around and is like, you see this, Ish? Or whatever. That's an imminent threat to me. I don't know. I'm not taking that threat.
Common sense examples of this notion of conditional threat, from this, the real world. If you flirt with my girlfriend in the gym one more time, I'm going to kill you. I says, fine, I'm not flirting with your girlfriend. I'm not going to do it anyhow. If you cut me off in traffic one more time, I'm going to kill you. It's a conditional threat. I'm not going to kill you for cutting me off. It's different.
Conditional threat is crazy.
By assessing reasonable risk. Let me just talk about this condition too. You want to know what the biggest red herring in this case is? It's where Jason Levesque put the snow. That's actually the point. Attorney Sisti got up multiple times to point out with different witnesses, hey, that's not on his property, is it?
It's not.
It's pretty close. You heard from a bunch of different witnesses. No, not on the property, on his property. That's the point. The condition of the threat hadn't happened. And Kyle is literally saying that. He's not saying you put snow on my property, therefore I'm going to kill you. He said, if you drag that stuff out of your driveway and push it down in front of my driveway, then we got this problem. Didn't happen. According to Jason, it wasn't going to happen. And that literally redefines the notion of this threat. That's the point. It didn't happen. You can actually see Kyle continue to explain the conditional nature of it when he walks away from this nose-to-nose encounter. He's pointing at that snow and his own driveway. That needed to happen. And it diminishes any notion that Kyle Violet is about to act on anything.
Yeah, and I think that's, y'all are saying in the chat, that's the thing that bothers me. I love how we're just skipping or glossing over the fact that Kyle went into his yard and threatened him. I don't think anybody's denying that. What they're saying is, oh, well, it's a conditional threat. Come on, man. Are we really going to say, hey, okay, world, it's okay to threaten your neighbor. It's totally fine to walk into someone's yard and say, hey, tomorrow at 6 o'clock, I'm going to come out here. I'm going to look at this snow. And if I see that snow is melted and there's water in my yard, I'm going to your family, and it's going to happen. So you're supposed to let that person just turn around and walk off. Okay. That's fine.
The law actually recognizes this.
That's the law, so I can't be mad if that's what he's saying. I don't think this threat was conditional in that case, though.
Complying or not complying with the threat. Here it is. This is in the justification of self-defense statute. A person is not justified in using deadly force on another to defend himself or a third person from deadly force by the other if he or she knows that he can comply with a demand that he or she abstain from performing an act which he or she is not obligated to perform. That's a very legalese definition.
Yeah, but
conditional
read
threat.
the
In
whole-
other words,
read the
if
whole
you don't
thing.
have to perform this pushing snow in front of the driveway, of Kyle's driveway.
I love
you
how he
can't
just
use
read
reciprocal
part of the
force. You
law.
can just not do it. You know, here's the difference. If somebody comes up with you with a knife and says, look, give me your wallet. You don't have to comply with that. You can take your gun out in the face of a knife, in the face of the threat, of something that you don't have to do. You shoot them if you want to. Somebody comes up to you with a knife and says, hey, look, if you ever come into my home again and steal my wife's jewelry, I'm going to kill you.
How is he justifying
you
this?
not only have an obligation to go into their house, you have an obligation not to. So it's sort of a very clear example of a conditional threat where you don't have to comply with it. There's nothing about pushing snow in front of in front of Kyle's property that he had to do and was therefore imminently threatened by it. And I get, we're spending a lot of time on this. My point is,
I think he's making Kyle look
in
worse.
this particular case, words matter.
I think the prosecutor's making Kyle look worse, because what's Jason supposed to do? This man just said he threatened to kill me and my family if I put snow in his yard. So Jason should walk over there, look at the pole and the snow and say, oh, okay, we're good. He's not going to kill me. It looks like, hey, Kyle, look at this. We're right there. It's on this side. So we're good. Okay, no worries. It's not an imminent threat. It's conditional. See, because the snow, Kyle's a reasonable guy. You can kind of see the snow is not on that side. So we're fine. Have a good day, neighbor.
Let me also just talk about the law, doesn't take away all options. I think we talked in Vladimir about sticks and stones can break your bones, but words will never hurt you. And that's a kindergarten notion of it. And we accept that in the real world out there, words can be scary. And threats that you probably don't hear in kindergarten, like, I'm going to kill you and your family.
Well, some kindergartens.
So there is another layer.
Depends on the kindergarten.
And it's this. You're allowed in New Hampshire, under the same justification self-defense law, a person who responds to a threat, and this is as opposed to imminent deadly force, to a threat which would be considered by a reasonable person as likely to cause serious bodily injury. In other words, the basis of the threat is something like, I'm going to kill you. You can respond to that by displaying a firearm or other means of self-defense with the intent to warn away a person making that threat, and you don't commit a crime. The law has anticipated this very moment where it's just a threat, but not imminent use of actual deadly force.
That's
But
up
the
to
threat of
Jason
deadly
to
force,
decide.
if you're armed, you can produce your firearm and say, no, you're not. It says nothing about them being able to shoot them for retribution, for your anger, for your offense, for your sense of honor. You can warn them away if it's a threat. And to be clear, Jason Levesque never claimed a standalone threat. He got up on the witness stand and made that claim because he's got to. He's got to get away from this notion of conditional threat, got to get away from the notion that he was just entitled to brandish a firearm. He got up there and said, after the nose-to-nose encounter, he walked away and said, you don't believe me? I'm going to kill you. Here's the problem with that. This is a credibility issue. When he talked to the detective, he didn't say once, he said twice, in clear terms. Again, this looping effort to clarify, is he committed to this specific issue or not? Said he stepped away, he was walking back towards his house, it was after the gesturing, and Kyle turned at some point. You got to ask yourself, is that in response to the defendant saying something? Because his response, according to the defendant that night, was simply, what, you don't believe me? And that had him walking back, sounding very much like an exchange. The bottom line is, no, there was never an additional standalone threat despite his claim. You saw this process work out, how it works. I showed him the transcript, 2 places where it was very clear that there was no standalone threat, and he said, oh, it's in there. If it was in there, you saw the process work out. His attorney could just as well get up there and show the transcript where I was being tricky and omitted it and say, oh, no, here it is, but that never happened. The reason that never happened because it's not in there. Jason Levesque never claimed there was a standalone threat. As I say, there's nothing appropriate about that threat, but Jason had legal recourse to brandish his firearm. Does this case change over his claim that his daughter was threatened? It doesn't. The same reasonableness, the same imminency of deadly force would have to necessarily apply to the daughter. And here we know, I'm not saying it's appropriate, but here we know that he never used even the term daughter. We don't even know that Kyle was aware that she was in the truck because he never gestured towards her, never pointed towards her, never invoked her name, or even specifically daughter. It's a broad brushstroke, horrible, inappropriate threat, but not one that imminently targeted his daughter, not this case. You know, we talked in kind of candid terms during voir dire about, you know, whether threats change for you if they concern your family. And of course, everybody's initial visceral response is, yeah, you threaten my daughter, I'm going to kill you. And that may well be, you know, a natural initial reaction.
Yeah, I want to see the video
but
too.
This is for real here. You know, this is now the application of the law and the consideration of real-world consequences. This is not a conversation with, oh, your friends and family around the dinner table. This is what I'd do if somebody said that. This is the realization of what actually happens, you know, when you shoot somebody.
Show the video again.
Response to being offended, to thinking there's some street notion of retribution that is appropriate. This is real world. And now we're going to apply real world standards. What happens next was the walkaway and return. The walkaway is important concerning, again, two issues: time, space, opportunity, diffusion of risk. Kyle walks away at least 15 feet away. The nature of the threat necessarily diminishes. If he has a screwdriver that is, you know, sort of fancifully filling Jason's mind, he hasn't not only referenced it, it's purely fanciful. It's not a reasonable belief, but from 15 feet away, screwdriver isn't going to do much good. You know, this whole issue of, well, he didn't go through a mag detector, so Jason didn't know whether he had a weapon.
Only the courtroom cowbell. I can't find it.
A weapon. He didn't display a weapon. He saw his hands clear. But here's something to consider. What Jason Levesque knew was that Jason Levesque was armed. In other words, from that distance, he could have easily, if he was really concerned about imminent use of force from some weapon, he could have drawn his weapon. And at that point, still, he does not. Kyle is gesturing to the snow, gesturing back, really corroborating, if nothing else, just his conditional threat that snow needs to be moved before we have a problem. He turns back to his own house, and as I said, there is no new threat. His hands are in the open. But he does clearly walk back towards
yeah, for sure.
Response to, again, a comment or
for sure,
an exchange. We don't know because we can't pick it up on the audio. And then again, he brandishes the firearm. And the state concedes he's within his rights based on that threat statute. They said you can brandish it to a threat. You can't use it unless there's imminent deadly force. And here's where things go south for the self-defense claim. This is the ace, the second ace.
All right, here we go.
It worked. Brandishing the firearm worked. You can see Kyle Violette stopped. And it's not milliseconds before he was shot. There is time.
I see what he's saying.
Revisit this on the video, and I don't mean in a hyper-technical sense. View it from the claim that Jason Levesque is making. Oh, this was a millisecond. It's not. He pulls out his firearm back by the plow, and he starts closing the distance, clearly indicating he knows he's in control now. You don't close the distance if you're afraid somebody's going to break out a weapon, a throwing screwdriver, or anything else.
You close the distance to eliminate the threat.
Raises the firearm, and with unambiguous certainty, Kyle Violette stops. And he doesn't merely stop. He turns away. And you can see this from multiple angles. You can see this from that garage view. You can see it from the side of the house view. You can utilize that evergreen where you see him just come into view. Gun comes out, and he goes out of view. You can see it from the porch perspective, which is down at the feet, imperfect. But critically, what is visual is that his feet become reoriented, stepping away. Both feet are now oriented to across the street. He's clearly turned. This is before he's shot. That's time. Opportunity to see the threat diminish. to see that the brandishing of this weapon accomplished its end as justified in the law. And yet, he closes on him and discharges a firearm into his head, into his face, crashing through, smashing his jaw, and dissecting his carotid artery.
Yes, deadly force.
He's in control. That was entirely unnecessary, unreasonable, unjustified. An unarmed man stopped and turned away from his gun, tried to kill him.
Deadly force is generally defined as force that is intended or likely to cause death or serious bodily injury. So 1 shot, 20 shots. Was he allowed to use deadly force? That's really the question here, and the question we've been asking for a while.
The next 5 rounds, he shoots him in the back. The time frame is something like, and you can listen to the video from across the street that's just audio. It captures the first gunshot clearly. And do the count. Something like 4 to 5 seconds. Think about that. 1001, 1002, 1003, 1004. Bam, 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 bam. It's unconscionable. He's on the ground, crawling for his life. That's attempted murder. By the grace of God and the intervention of immediate medical assistance, he lived. That's attempted murder. You know, this is incredible claim that we heard yesterday. You know, I asked him, do you think he's still a threat to you? Yeah, he was crawling towards my parents' door. Literally said that. That's incredible. It's like the cyborg scene out of The Terminator where the thing is crushed and still crawling on the ground and it's, you know, pursuit of murder. Except this isn't science fiction. The fiction here is from Jason Levesque, that Kyle crawling on the ground with a nearly lethal, certainly would have been lethal without intervention. Gunshot wound to the head presented some sort of threat to him, his family, or anybody else. The other thing he's crawling towards is his home. And that's obvious. And once again, we know there are other factors to show that Jason had no sense of impending threat or injury to him. He lowers the gun. You can see that in the video. He lowers the gun before he advances some 3, 4, 5 steps closer to the supposed threat before he unloads the additional 5 rounds into his back in lethal fashion. Look, you got to analyze that in terms of reasonable force, reasonable belief, and the imminency of threat. These are the moments. It's not the nose assault. Let's talk about intent to kill. We need to prove that. You could form a purpose within the meaning of the law in a moment's time. You need to have the conscious object of a certain result. There are plenty of practical examples of this, of bad decision making or regret doesn't take away the purposefulness of a decision. Geez, I shouldn't have had that extra martini. That didn't mean I didn't take out a shaker, a glass, pour gin into my martini glass. I may regret that, but I certainly still acted purposely. It could happen in a moment's time. A decision to pick up this glass or that glass is still a conscious object and a decision. Here the steps, though, are much more conscious and involved. Each act purposely. To take out the gun from a holster, to raise it and aim it, to advance towards a target to ensure greater accuracy and lethality, to pull the trigger, to watch him fall, to watch him crawl, to advance on him, to aim again, to pull the trigger each time. This is not an automatic weapon that just sprays out 6 bullets. Each time he pulls the trigger is a purposeful, conscious act seeking to create a result.
True.
That's an ace.
Yes, Jason was allowed to have the weapon.
Look at the nature of these wounds. A headshot, 5 additional shots that each found potentially lethal marks. He's got shots in both buttocks, clearly indicating he's not a threat, but all those shots were potentially lethal.
He got shot in the butt.
Doctors say that each one was in an area of critical vascular nerve and organ systems. One of the bullets through his buttocks blew out his abdomen, dissecting his bowel, requiring emergency surgery. Need I go into the details of these images, which the defense on the one hand dismisses as unnecessary, but at the same time, Jason Levesque gets up there and he is asked that critical question: why did you shoot him? Did you intend to kill him? No, I just wanted to stop him. Look at those images. Play that body cam of Sergeant Hurley saving his life. And you got to ask yourself, is that the intent of somebody just trying to stop somebody or kill them? That's an ace. Let me talk about Jason Levesque's claims that he made to Detective Garson. Confusion, memory,
Taco Tuesday loves bringing up him getting shot in the nut.
Lies.
That's crazy.
That he made, that we talked about, were central issues required for self-defense. He didn't just happen to, stumble upon some misstatements. These are not the misstatements of, confusion. Misstatements of fatigue, like his distance was off. Fibs to cover for his pride or embarrassment. They are essential features to support a non-existing self-defense claim.
He said he misremembered.
You had a bad memory. You were so confused or overwhelmed, you'd say to the officer, you know what, I don't remember that. I don't remember that moment. I'm confused about that moment. But he never said that. Instead, in response to Garson's questions about, well, what happened after you took out the firearm? He gives a vivid, pictorial account, a visceral account. He said, I took out the firearm. Did he stop? No. He continued to advance towards me. In fact, he hastened, his words, hastened his pace towards me. It had been 10 feet away, but then he rushed. And I could see in his eyes his aggression. All of it, complete fabrication and nonsense, but all of it essential for a self-defense claim. So what did you do? I fired. Stay on his feet? Yeah. That's not confusion. Confusion, I don't know what happened. He gives a very precise answer. Why? To justify the next 5 shots. Did he go down? No. He didn't appear to flinch. Maybe he flinched because of the noise. But I don't know if I even hit him.
He was this much of a mastermind after being tired and working that long?
Yeah,
I
that's
don't know.
why I had to unload those next 5 rounds. That's not confusion. That's not, I'm not sure what he was doing.
Yeah, I don't know.
He's coming at me. And he gives this vivid, nonsensical. The degree of mendacity is breathtaking. He literally says, I shoot him 5 times, and he holds his abdomen and turns away and walks back to his home. That's a self-serving lie to fabricate self-defense because he knows what he did was wrong. And it doesn't.
He said, watch the
Otherwise,
video.
we'd see kind of this random confusion of facts that some support, some don't make sense, some aren't corroborated. But it just happens to be that each lie is such a divorced distance from truth and happens to land squarely within a set of facts that would support self-defense if true. But we got some aces. We got videos that demonstrably show he's lying. Let me talk about some other aspects of the defense claims. That he was tired at the street side and therefore was having difficulty. We've got to adopt this 40 hours of sleep. First of all, that whole notion that he was up for 40 hours is a credibility question for Jason Levesque.
What?
He's working for a commercial plow company that has some liability, and you think they don't give them breaks over the course of the day, that they're not conscious about the amount of time somebody's on the road.
He was still
he's
working,
operating
man.
a commercial
Come on.
plow where apparently even at that hour he is able to make precise judgments and assessments of distance, of force.
I would object. I would have objected. I'm not a lawyer.
Safely there, but he's too tired in the next 5 minutes to make rational assessments about risk and whether or not the defendant, Kyle, is on his feet or not after getting shot in the head.
Objection.
Let me just say, he's not tired in the sense that that he's absolved of responsibility. He may be sleep deprived and dangerous, but that's a different matter. How about that he consented to the videos? Look, he's sitting there in the, this is another immunity card from the defense. Well, he gave him the video. Look, Garston heard about the video earlier on. He looped back at page 66. He hears about it at page 27, but he's the one who says, hey, you got video from tonight? And it's true, the defendant signed over the video. Do we know whether he's thinking, hey, maybe there's a Hail Mary here, that there is a kind of a perfect convergence of omission? It was pretty close. I mean, one of the videos just has him coming into view. The porch video is facing down. The garage video has only the sliver. And do we know whether he's making that calculation or not? I don't know. But we know he couldn't count on 43, pulling it all together, getting that arc of a view, that if you see these things in conjunction, you know that Kyle Violet stopped when the gun came out. You know, with the totality of these videos, that he was closing the distance. You know that there was sufficient time between brandishing the firearm, Kyle stopping, and pulling the trigger to assess risk. You know he went down after the first shot, and you know he came over to try and execute him with the next 5. That he gave them that video doesn't change any of that. Those are 4 aces. I hope he doesn't do anything stupid. Look, you want to talk about red herrings. Let's assume he's talking that she was talking about Kyle.
Yeah.
Stupid doesn't mean that he's going out there. What she doesn't say is, boy, he's armed and dangerous. I hope he doesn't go out there and kill him. Stupid is going up and putting your nose in somebody's face and making a horrible threat that could have resulted in him brandishing a firearm or getting punched in the nose, but nothing about, geez, I think he's going to go out there and kill him. Red herring.
What? What is the argument
Let's talk
there?
about,
all right, I'm going to leave it alone.
Mantra.
That's crazy.
Claim from the defense that Kyle Violet is a lunatic, a maniac. Look, maniacs run out into the road with a bloody axe and threaten you. Here, let's not forget the actual facts here. And they want to omit, the prior event with the snow to make him look like a maniac.
Well,
you heard from Kyle's daughter. That's got to be one of the most objectively grounded, reasonable, pleasant witnesses we've seen. And she described being at home with her dad, who she adores, and planning a family night, sitting down at dinner, planning to watch a movie, but everyone went to their room, and they were getting apprehensive about the Plow not showing up, and that they were all going to have to get out there and shovel, and the anxieties went up. And even Kira, Jason's daughter, acknowledged that, the first storm, we did plow in front of his place. And they did say something. We said, it'll melt. And so there was anxiety about that. I'm not suggesting, again, that the threat is reasonable. I'm suggesting it's not maniacal, that there is context for this, that there's history for it.
What?
Don't put that in front of my driveway again. It sort of diminishes the maniac view of this, doesn't it? And likewise, let's go through.
no, how does threatening to kill someone... How is that diminished, period? Anybody that would say, I'm going to kill you, is a maniac. Why would you go to somebody and say that? I don't know. This is wild.
Just some of these other efforts to assail Kyle's sort of humanity. The so-called prior event. What was that about? Talk about innuendo. I mean, we had, once we got into the detail of it, it's like, well, who is this guy? I don't even know if he was my neighbor. I couldn't pick him out of a lineup. Did you call the police on Kyle? No. Did you see Kyle again before this? He might have been taken out of his trash. You can't even identify that dude. And they're bringing that forward as some sort of an assault on his character, to create an image in your mind that is much different than the guy who was having a family dinner and got anxious about having a hand remove snow. That's not fair. What about the claim that when Jason returned to his vehicle, that he told a joke about running? That is more breathtaking mendacity. Somebody who just shot somebody this side of death can't possibly tell that kind of a joke unless they're a sociopath.
What?
And you know what? He has to recast it again, very much aware of his self-defense claim. If he got up there and admitted, yeah, he was thinking of running, it's an admission that he knew what he did violated the law.
No, it's not.
There's only people who
Nobody
violate
sees
the
it like
law
that.
and want to avoid legal recourse and consequences. Run. First thing he says to his daughter is, should I run? And this isn't just a passing, moment. You heard what Kira had told the police. He asked me, should I run? I said, no, you can't run. And he doesn't stop it there as a ha-ha joke. He says, well, then what should I do? Her response is not, oh, ha-ha-ha, you're joking. It's, this is your path. You've got to figure this out. Should I call 911? I don't know. And no, he doesn't. That's not a joke. That's an admission of a guilty state of mind.
You don't know
Immediately
that.
after these events.
Come on.
I'm in trouble. Not because he came at me after I brandished the gun. Not because he continued to come after me after I shot him in the head. Not because he continued to be a threat lying on the ground, bleeding to death from a dissected carotid artery. Because he was in trouble. He wasn't justified in shooting him, and he knew it. And that brings us to the police station where he contrives these litany of self-serving lies. We had heard in opening that, if Kyle wanted to kill him, he could have. He could have gone back and got another magazine.
Yep, that's what I mentioned too. He could have reloaded. That would have been excessive to me.
Depict Kyle's intent. Excuse me, Jason Levesque's intent.
He doesn't even know
Kyle
who was
Levesque
defending.
was as close to dead as you can get without a funeral. This is the intent to kill. There was no
We're all close to death,
discretion
my
on the
friend.
part of the defendant to temper his use of violence. You got to weigh the reasonableness, the degree of that violence in light of the actual evidence. Take a look at it. I want to talk briefly then about this notion of Kyle's actions that create then a reasonable belief. He's on the ground in one instance and stopped in the next. And now you've been invited to view Jason's perception of that and to simply accept that whole cloth. That's not the standard. Jason needed to have believed he was in imminent threat of receiving deadly force. We know he wasn't because he was in control of the firearm. We know he wasn't because Kyle stopped. We know he wasn't because Kyle was crawling for his life when he received the next 5 rounds. But so that's the first prong. Even if you get there, you do get to evaluate this objectively to determine whether it's reasonable. And to dismiss it simply because he was tired is not the law. If he was tired, he should have used extra caution and care with a firearm and the actual use of deadly force. Being fatigued is not an immunity card. It doesn't dispense with objective notions of reasonableness. We literally heard from Jason Levesque up on the stand that, you know what, I don't even know what self-defense is. You lawyers getting tricky on me with this defense notion, self-defense. I didn't know what it was, therefore I couldn't have been contriving it. Here's a guy who explained that he carries a weapon because of a prior incident with some machete. Of course he knows what self-defense is. He literally explained that's why he carried. And yet we're supposed to believe he's too confused, too ill-informed, too tired to reasonably weigh out self-defense.
That's not really what he said, but
he knew self-defense and that's why he lied.
he's saying self-defense
He
law.
knew self-defense, that's why he carried and was supposed to carry responsibly. Look, ladies and gentlemen, I want to sort of address and end on this issue, another concept that we heard in opening statements. At one point, Attorney Sisti said, basically, this is the theory of the case. Kyle Violet got what he deserved. You know, first of all, to assess that, you got to take a look again at what Kyle got. And it's in these pictures. This is what Kyle got. And it was all from words, grossly inappropriate
Right.
words, but words nonetheless, not married to, not advanced by actual threats. And it is, at this point that we invoke justice. That, I told you at the outset, it sounds kind of corny, and if I said this around my Thanksgiving table, I'd be asked to leave, but embedded in our civic duty, our civic culture, justice is sacred. The process of achieving justice is embedded, provided for in our Constitution, a process of determining justice. And it doesn't require that you abandon, as you've been invited to, scrutiny of Jason's actions, that the frame-by-frame viewing of whether he stopped or not is unfair. Because that's exactly what we do. We don't, get shamed away from judging these kinds of actions. What we do to achieve justice is, in fact, invoke this process. The prosecution has a burden to come in and present evidence to a group of citizens, jurors, who take an oath. This process makes our system of achieving justice probably the best in the world. Not perfect, but probably the best in the world. You evaluate that evidence in light of our burden, but using your individual and collective common sense and apply the law. You do that in this case. The path to justice is, in fact, guilty verdicts on both indictments. I ask you to endeavor on that path.
All right, there it is. Prosecutor closing statements, finished right at noon. What do y'all think about this? I think he did make some decent points. But in general, we got to look at the law. Was what he was saying about the law is true? Was Kyle an imminent threat? Did Jason believe he was an imminent threat? And is there enough reasonable doubt on one or both sides of this argument for the jury to say, I think Jason is justified in what he did? Y'all have to let me know what you think about that in the comments and in the chat.